Hey guys, I'm sorry I wasn't back at 2. Wait a few minutes because nobody's here yet. Wait for everybody to get their notifications. I guess nobody has their notifications turned on. I was almost back at 2. I was close, y'all. We were supposed to be waiting with bated breath. Where is everybody? Did I rush for nothing? Oh, there's somebody. Hey, Carla. Why is it behind me? StreamYard. I just ran out, got the stuff I needed. Got the money out of the ATM. Didn't even went to the post office. It was closed because our post office sucks and does not go by the hours listed on the door. Because I live in BF Egypt, Florida, and they just think they could get there whenever they want to. They don't have to be open when they say they're going to be open. Because what sense would that make?
Information that does not contain
Wait
the long list of materials that you just rattled.
Was that from this morning? I thought that was the afternoon one. Did I rush back for nothing? Have they not started yet? I thought that was the afternoon. No, this says live right now. Started streaming 5 hours ago. Oh, they didn't break it up into 2 sessions. This is on crime. We were on court TV.
Can you do it before you finish? Well, let's see where we get with the motions, and we'll see about that.
And Your Honor, if I could I finish that last point that I was about to super clear about this one point? What Mr. Brennan referenced, and I understand why he would reference it in the transcript of the Gretchen Voss interview. The reference to the she called John and talked about Ashley's home or Ashley's house. The she was Jennifer McCabe. But on the 28th, calling John to say 34 Fairview is down the street from Ashley's house. My client was not part of that conversation. That was between Jen McCabe, as she testified, and John.
Okay.
Then the next day is when, and could it have been some sort of an interaction or an affair or something like that?
Okay.
There was no animus, no evidence of animus on the night in question.
I understand that's your position. We haven't heard the evidence yet.
Okay, I just want to make sure.
All right.
Thank you.
All right. Well, Mr. Jackson, you can stand. Been pursuing a third offense. So you get 2 minutes, Mr. Yannetti. That's yes or no, and then I'll hear the Commonwealth.
I'm sorry, I did not hear the question.
Yes.
All right. So I'll hear you on your motion, Mr. Brennan, and then a 2-minute response. Jimmy, keep track, please.
Yeah.
Go ahead.
Thank you.
The weather is bad here right now. I don't know if that has anything to do with StreamYard being a pain in the butt or not.
Or identification of the walls or the length of third-party culprit. The varying time make very unclear. A person includes particular people. No. We know from the defense statement that the party culprit was. That position changed in the Ted Daniels and position that they did not know who the third party culprit was. In our argument the other day, Attorney Little identified Brian Albert.
Well, the third party culprit is Brian Albert, Colin Albert, or both of them. And who knows who else?
In our argument the other day, Attorney Little identified Brian Albert as third-party culprit, Mr. Albert. And so there's this vacillating position. Evidence they suggest supports third-party culprit. I took an opportunity to go back to the arguments last year for third-party culprit. I have a transcript, and it's equally undefined at that point. And so what we have now is the defense with a hope or an expectation or intention to pursue third-party culprit, but we have no basis for it. The court has been very clear on third-party culprit. And they can't just come in and start accusing people arbitrarily of committing the crime of murder. Section 1105 of Mass Rule of Evidence makes clear that evidence that a third party committed the crime charged against the
So
defendant.
I will read again the Mass Guide to Evidence. I'm familiar with the law on third-party culprit. Your time is up at this point. All right.
What? That's not directed at me, is it? What happened?
You for 2 minutes on that.
My 2 minutes start when I get to the podium.
Yes.
Thank you.
The can be understood is impermissible. I'm fully
Streamlard, you are getting on my last nerve now, dang it. Oh. Yeah, they're arbitrarily accusing her. Stupid StreamYard, stop it. Spike, hush. I don't need problems from you, too.
read the transcript. I went back and watched the video. the Commonwealth states that they want to conduct, I'm reading verbatim on page 1, a courtroom demonstration of how data was stored within Jen McCabe's cell phone. That's it. No elaboration what it's going to be. They're looking to me it's a blank check. Similarly, with regard to Jessica Hyde, with courtroom demonstration, there's in particular information of importance. Vague again, we have no idea what it's going to be, nor does the court. And there are similar statements in also on page 2, they concede that disputed software administration would closely mirror the actual Google searches, but we don't know how. It's obviously not going to do it. And lastly, with regard to the law, deductions or inferences, that's right in the note to the rule, and that's exactly what they want them to do, is to give the deduction in the that the 220 times it came to at 6:30. It's regulation rule. It's essentially under 1006. The appeals court, the presentation selectively presented excerpts of other exhibits and evidence in the defendant's case. It was not merely a neutral summary. It was more akin to an argument than evidence. The Commonwealth concedes that's the case. And with regard to Commonwealth v. Sosa, page 14, the only thing that was allowed in Sosa, the case they cite, is that the complete video several camera angles of the property, and the video merely was a compilation of that which already existed. They just shortened it down. What they're proposing to do is anything but that.
All right. I appreciate your brevity too. Thank you. Mr. Brennan?
Thank you.
He's so cute, trying to go fast.
The demonstration we would be asking Ian Whiffen to engage in is the same demonstration as he did at the first trial. No different, based on the same qualifications, based on the same experience. It is essential that the jury understand and be able to see the data in action so they can appreciate the legitimacy of how the data is stored, how those windows are open. As far as Jessica Hyde, we've provided a number of different reports. We would like to provide chalks that come directly from those reports. So if there's anything that's particularly offensive in those chalks, I'm willing to discuss it with the defense. There would be nothing new or different than hasn't already been provided. It would be simply blowing up the photographs or the exhibits in her reports so that the jury can read along.
Thank you very much. I'll get a decision quickly to that. So the defendant to bring up any bad character or misconduct of John O'Keefe or any witness.
No, bad character evidence is inadmissible.
Right?
To the extent that evidence could be used for like motive, opportunity, all the under proposed rule 404, we reserve the right against John O'Keefe.
What do you say, Mr. Brennan?
If we have advance notice, I think that's appropriate. I don't want to wait until we get the sidebar. If the defense has an intention of offering what would otherwise be prior bad act evidence, but they think it meets an exception under the rule, then they should propose that evidence. We have time to consider it.
Especially if you intend to open on it. Are you doing the opening, Ms. Giannetti?
I will not be doing the opening this time, and I do
Okay.
not believe we will be opening on that at all.
All right. So, okay. So what I'll do is not during the opening and only with advance notice and a ruling.
What would the advance notice be, Your Honor?
A week before, a week before the evidence starts.
Thank you.
Okay, that's paper 587, Mr. Clerk.
Thank you.
Commonwealth's motion for an offer of proof regarding calling District Attorney Morissey and victim witness advocate Steve Nelson. And it also includes a request to exempt from
No
sequestration.
objection to strictly to trial strategy and attorney work product. So any such offer of proof, we would ask, we make that ex parte. I can tell the court just to kind of streamline things. We would not be seeking either of these individuals in our case in chief. They would be merely impeachment if necessary.
Okay,
Certainly, we could make those offers of proof at the appropriate time.
okay,
Thank you.
all right. I'm satisfied with that. What's the Commonwealth's position? You satisfied with that?
I am. I would like the victim witness advocate to be able to.
Yes, the victim witness advocate, he'll be able to come in for trial.
I wasn't.
So the other motions do seem like they may take a little bit more time. I'm going to well, actually, let's try this one, see how we can do with this. So the Commonwealth's motion eliminate to prohibit reference to the pending internal affairs investigation, sustained findings unrelated to this case or founded allegations. Well, this is in a little bit different posture now than when the Commonwealth filed it back on March 10th, right? With Michael
is.
Proctor being fired. Do you need some time to reconfigure this, or you want to just be heard? And for this, I'll give.
When we learned this is something I'd like to review. I'm expecting that there may be many pieces of material in that production that is going to be relevant. And if I have a chance to review it, much of it I may not object to, but there are some fundamentals of advisory board or a body aren't admissible. So there will be some constant
You feel the rules require you to forward, and then if there's anything else that I have to decide, how long will it take you to review it and provide defense counsel with everything that you believe you're required to provide them?
They have a copy of everything that we got.
Oh, okay.
So we had them on the email so they could get everything that we received. We don't have anything they don't have.
Oh, okay.
So it's really just an evidentiary argument. Can, for example, a firing, can that come in that he was fired? Can the conclusions of the board come in, whatever their positions? Maybe they found him acting unbecoming of an officer. I don't know, but the conclusions of what else we object to. The raw material, I haven't read it. I hear it's voluminous. Need some time to read it.
Okay. How much time?
Well, I would need, I think, till the end of next week.
Is that a same timetable you would have whoever's arguing for the defense?
That's fine, Your Honor. I just asked noted what specifically the Commonwealth is seeking to. There were some,
Right.
even just in the motion, inconsistencies.
Yeah, but I think it's all now.
Exactly, but just inconsistent title and what's actually in the motion. And I know what the.
You expect clarity from.
The day before
He doesn't
impanelment
know what the
can
word
deal with.
clarity means.
The court's available.
Want to do that? Yeah,
That's fine, Your Honor.
I'd rather, I think it makes sense that we at least give you time and weekend. If you go through it, I'd like something by next Friday too. If there are materials that the two of you are disagreeing about, so that I can view it next weekend and then we can have a hearing the following Monday.
Yes, Your Honor.
Okay?
Does the court intend to have a hearing on the Monday after that? I just would like some time to be able to review their position so I can have time to respond.
So you need until next Friday. I'd like to do it before we start the trial, but I suppose we could start the trial and then hear.
That's fine, Your Honor.
Okay.
Obligations over the next week. I'll try to facilitate it. I just don't know.
All right. Without knowing how much is in dispute, Ms. Little, you have no idea how long it will take you to address that, right? So,
Correct.
um, all right. So, Mr. Brennan, by the 28th, you're to provide the defendant with anything that is disputed, and or that you feel should be excluded. Can you provide that to the Commonwealth? I'd like you to let me know as well.
I will.
All right, and then Ms. Little, why don't you tell me on April 1st how much time you need to finish up? It may be nothing, you may have it, and we can do it. So I guess we won't meet on the 31st on this?
Thank you, Your Honor. I appreciate that.
All right, so on the 1st, you'll tell me how much time you need. All right, so Mr. Brennan, start making good time, and I'll let you go back and finish what you were saying when I gave you a 2-minute, when I cut you off after 2-minute on third-party culprit. And then Ms. Giannetti, I'll give you both up to 5 minutes on this. 5 minutes is a long time, Ms. Giannetti. Let's see how you do.
If the court's inclined to admit the evidence, then I don't need to speak at all. But if
Well,
you're,
last time I said I wasn't excluding it, you just couldn't open on it. Right? So that's where I'm at this point, and I'll hear the different sides. So,
if that's the ruling, Judge, I don't need to be heard.
and I know, Mr. Brennan, you wanted it in advance, but, you know, I guess I'll hear you on your motion on that then.
The requirements of providing evidence to support third-party culprit are clear. The evidence has to be relevant, it can't be speculative, and it can't tend to prejudice or confuse the jury. If it involves hearsay or inadmissible evidence, there has to be a substantial connection between the crime charged. And so what we would want to avoid is what appeared happened in the last case when it was just a broad-based attack on anybody. There has to be relevance between who they choose as a target and the crime itself. Looking at the transcripts, I do not see that they've met a substantial basis between any particular individual and John O'Keefe. If we start from the premise that every single witness who testified that John O'Keefe never entered the home at 34 Fairview.
You're all lying.
Every witness. There is no substantive evidence that John O'Keefe ever entered that home. So to open up an invitation for the defense to start to present evidence, sometimes alleged prior bad act evidence or character evidence, is unfair because then it becomes a mini trial for each witness. And so I haven't heard any basis or any proffer by the defense that would substantiate any particular witness is a third-party culprit. Now, there are some cases that saying you don't have to actually identify the witness. Those are particular circumstances where there is still substantial evidence that an unknown person had committed the crime. That is not the case here. They have used names liberally, randomly, and those names have changed throughout litigation, whether it's in trial, after trial, but we've never seen a proffer by them. Who is it that they're going to claim as a third-party culprit? What evidence do they have that they want to introduce? There has to be parameters and limitations if they're going to try to introduce third-party culprit evidence, not only about who the person is, but what evidence are they going to introduce? Otherwise, we're going to spend half the trial at SAR by fighting whether this is substantial, whether it's supported. And so no proffer has been made. I think there's an obligation to the defense to identify who the third-party culprit is and what do they want to introduce. Do they have a witness? Do they have evidence? Do they have any records? Simply assailing people's character randomly is improper, it's unfair, and then it causes the Commonwealth to have to spend extraordinary time rebutting, which is going to confuse this jury, and it's prejudicial. So I think that the court should order the defense to articulate who they claim their third-party culprit is and exactly what evidence they're going to introduce to support that claim. It's not until they articulate it we can really fashion an argument for the court, whether we think it is appropriate or whether we think it's insufficient. But now it's just an empty box where, as in the last trial, the defense can simply get up and blame anybody and everybody. And that's not the way the court and the courts have seen third-party culprit evidence. There's a standard, there's an obligation. It hasn't been met. So at this point, the court should preclude third-party culprit evidence. They shouldn't have, they could certainly pursue some type of critique on the police investigation, but as far as third party, without a proffer and a finding, there would be no guardrails, there'd be no parameters, and it would be chaos.
All right, so Ms. Giannetti, I will hear from you, and I'd ask you to focus on, could you tell me whether this is pure third-party culprit, third party as it goes to Bowden, or is it simply somebody else did it and we don't know who?
It's the second alternative. In other words,
Okay, so that's a little bit different, Mr. Brennan, not pure third party. You can, a little bit different if it's third party as to Bowden. Admissible if the police didn't know about that third party and not act on it. So are you going to tell us who? Last time you told me you don't have to prove that, but can you make
it's
an
still our
offer?
position that we don't have to prove or narrow it to one potential third-party culprit.
Are you saying it's several?
Three, yes.
Okay, so can you tell me the three that you say it is?
Sure. So the potential third-party culprits that we have identified are Brian Albert, Brian Higgins, and Colin Albert. I have, evidence with regard to each. I'm sensitive to the fact, Your Honor, that, and I have a lengthy argument prepared detailing the evidence against each of them.
Do you want to put it in writing?
Well, I'm just sensitive to the fact that the court is seeking not to, pollute the potential.
So we can do this over here.
It's up to Your Honor.
Why don't I see you preliminarily over here?
Yeah, we're seeking not to tell the judge that is friends with the people we think did it. Who can now run back to them and say, guess what? They have all this evidence against you. How is this legal? How is this legal? In a free country. God. This poor woman. I'm just going to rant the whole time they're at sidebar. Sidebar. The whole time they're at sidebar, I'm going to rant. Where's my goat? And no other thing was investigated because of Trooper Proctor, who has now been fired. 100% now the house is going on, things have been investigated. Oh no, they absolutely alluded to them doing it last time. It didn't surprise me that they did names. Don't you remember the Bang Bang song from last time, Judy? had Colin on the stand and showed those social media posts that he said where he wanted to F people up. And then somebody made that awesome Bang Bang song with with him quoting Colin's Facebook posts or whatever social media posts. I love that song. That song was funny. I don't like it when people cuss, but that was a funny song. And AJ was just quoting, he said, and the reason I think he's involved is because of the text messages. See, now StreamYard is in on the conspiracy. They're trying to shut me up. So Colin's motive is drugs, that he was selling drugs and John was trying to stop him. I think Brian Albert, though, was just because he was trying to protect Colin. Hey, Jelly Bean. I don't know if they really came out and said names at the trial last time, but they made it clear. They absolutely made it clear who they thought did it. But they made it seem more like it could have been one of the three. The only time they made it sound like it was two of them together was Colin, because they made it sound like Colin started the fight and then the dog jumped on John's arm and then Brian hit him in the head with a weight. But the thing I still can't get over, crying out loud. It won't do anything now. It's gonna crash again. Hang on, y'all. I think it's fixing to crash. Oh no. Damn it. It muted me again. It just does not want me to talk about this. I don't think Brian Higgins did it. He might have been there. He might have been involved, but I don't think he was the one that actually did it. I do think he was part of the cover up, and I think Jen McCabe was part of the cover up.
The defense has to make a decision as to what you intend to provide me so that I can make this ruling. So, all right, next is the Commonwealth's. I know nothing about this person other than your motion just says that all you have is a CV. Does the defense intend to call this person?
I'm going to address that, Your Honor. How would you, I want to make sure I'm within your time constraints, so you want me to stand
Like
up?
2 minutes. Just my first question is, who is this person and why haven't you complied with your reciprocal discovery obligations?
Your Honor, because this witness is pending Dr. Crosby. And he's presented because of Dr. Crosby. So it depends upon what happens with that. If Your Honor is ruling on the motion for reconsideration, then we can have a better answer to your question. But that's the purpose, is to address if Dr. Crosby is going to be allowed to testify, and if so, as to what. And we're happy to provide, once we get that determination, provide all the things that I think Your Honor has in mind.
Or Poe, as Adriano D'Souza would say. Poe. I'm so fed up with StreamYard right now.
Court. So I can meet a fairly short deadline, assuming I can communicate 3 days.
Can you do it by Monday?
Yes, thank you.
All right,
Thank you, Your Honor.
thank you. So 6:07, Jim, is the defendant will provide reciprocal discovery by Monday, the 24th. I'll hear you on that, Mr. Brennan. And I figured this is probably lengthier than the others.
I'm sorry, Your Honor?
I figured this might be more than 2 minutes.
The defense would like to call
Watching them.
Mr. Easter to essentially testify about his personal opinions of the investigation, and then to purportedly give opinions about the police investigation, and to give opinions about their efforts regarding writing reports. This is, from my perspective, tantamount to having a witness come in and vouch for the credibility of defense arguments and essentially summarize arguments. This really, from my perspective, is the role of the defense attorney, to cross-examine the witnesses, to point out the inadequacies, to respond or explain or admit any type failures. That to bolster a potential Bowden defense and a third-party culprit defense. It would involve having Mr. Easter come into court and give his own personal opinions about who a target was or who a third-party culprit is. They would want Mr. Easter to come in and to go through protocol of the state and local police and point out what he thinks is failures. So essentially, he's a witness that would come in, promote the defense theories, tout reasonable doubt, and quite a bit of research. This is not a summary witness. This is not a witness that has any relevance other than his own personal opinion. This former FBI agent was a full-time member of the CAS department since 2013. He is not in a position to determine the best practices of local or state. If there are different rules and regulations that the defense will attempt to introduce, that will like information in data records or phone records, rather a summary witness of a witness who wants to come in and give their opinions about this case. I don't see any grounds for admissibility for Mr. Easter to come into this case and give his opinions regarding whether he thinks the police investigation was appropriate or not, or whether he would have directed somebody to do something different, and inevitably whether he thinks somebody is a suspect that was not pursued. That is all in the province of the defense in their case and in their cross-examination. So I don't see any relevance whatsoever of Mr. Easter.
All right, who's arguing for the defendant? So I need you to start by telling me what you expect him to testify to.
I can certainly tell the court that we do not expect to seek testimony or elicit testimony from Mr. Easter as to a third-party culprit.
All right, but who is he? He's a retired FBI agent?
Correct.
So what purpose are you calling him for? What's his testimony on?
To opine on the adequacy of the investigation. He is an expert as it pertains to investigations, investigative protocols, the adequacy of a proper investigation, what investigations should look like, what a proper investigation should
How
look
is he an expert on that? How is that a field, and how is he an expert on it?
I'll go
Is
through
it
that.
something he's done? Has he testified on that in other courts?
He's testified in dozens and dozens, if not hundreds of courts on issues related to investigations. He was a lead case agent for the FBI for many, many years. He taught issues specific to proper investigations and investigative techniques.
So do you have a report and CV and all that material
Yes.
that you can share with me?
Sure.
All right.
I've already shared it with the Commonwealth, but I'm happy to share it with the court as well. If I think I can address many of the court's concerns as it pertains to his expertise and why the law in the Commonwealth allows, in 702, allows him, someone with his credentials, to testify to a very specific issue, like, for instance, something beyond the normal capacity of a layperson or a lay juror, and that is proper investigative techniques. A lay juror might not know, for instance, that collecting items in solo cups or grocery bags would be improper. My Easter certainly would know that and could opine on whether or not that followed standard protocols. What he's not going to do to assuage the Commonwealth's concerns, he's not going to or we're not going to seek to elicit testimony from Mr. Easter concerning a third-party culprit or who that third-party culprit was, but merely what investigators should do when they walk up to a crime scene and how those crime scenes should be dealt with, etc.
So is the basis of his testimony just crime scene, like collection of evidence, or is it
Witness
when
interviews.
somebody tells you somebody may have done it, you're supposed to go follow all those leads? Which is it?
That too, both. Because if someone tells you as an investigator someone else may have done it, you're supposed to follow that lead. That is investigative technique. Of course it includes evidence, over how that kept those how you maintain evidence, things of that. Certainly, the 702 and very specifically 702 in the federal courts. It's literally, I looked them up, looked at them, and the advisory committee notes for federal rules of evidence 702 is very, very instructive on this particular issue, specifically as it pertains to somebody with the expertise in a field like crime scene investigations and investigative protocols. And what the advisory committee notes say is, quote, 702, the rule is broadly framed, merely limited to, quote, scientific and, quote, technical, the scientific and the technical, but extend to all specialized knowledge. Similarly, the expert is viewed not in a narrow sense, but as a person qualified by knowledge, skill, experience, training, or education. Thus, are not only experts
I'm so sorry, guys.
Specialized education beyond that of an average layperson, in particular, in a scientific methodology that we've heard so much about in some of these motions in limine. I can go through some of his credentials, but Mr. Easter is eminently qualified to provide the jury information about proper and investigative techniques, because the court noted.
Come on, StreamYard. Behave.
Or as I just noted to the court, he was an FBI special agent for more than 20 years. He formerly coordinated with multi-agency investigative gang task forces in Los Angeles. He worked with multiple agencies responding to dozens of crime scenes, including shootings, stabbings, abductions, child abductions, both domestically and internationally. He was the lead case agent who oversaw arrests and indictments. He received awards and recognitions for his work with the FBI, as well as with state agencies in which he was a task force member. For 11 years, he primarily assisted homicide detectives from LAPD, the Los Angeles Sheriff's Department, and the Los Angeles District Attorney, numerous other agencies as well, state and local agencies, with investigations and prosecution of thousands and thousands of homicides, robberies, kidnappings, other violent crimes. His work and assistance on investigations in LA and across the United States and ultimately internationally has been noted by not only the FBI, but those agencies as well. Just a few of Mr. Easter's experiences and involvements in some of the domestic and international cases include the 2015 San Bernardino mass shooting.
So are these all on his CV that you're going to give me a copy of?
Everything, I believe,
So I don't need you time again of the restraint. If you're going to give me a copy of the CV, I can read it. You don't need to recite it.
It's either what I was reciting is either in the CV or in his report. One
Okay,
or the
so
other.
that's what I need. That would be much more helpful to me.
Then I don't know what more the court would like for
So
me.
I
Do you have
wanted to know specifically what you intend to have him testify in a report.
every question I'm going to ask him, but I can tell the court in broad brushstrokes, obviously, we're going to ask him, we've already asked him to review, and from that he's going to, what I expect, render an opinion about whether or not the investigation followed standards and training, best case practices for an investigative
I guess
technique.
that's my question. So without seeing the report, where are there standards and best practices? Is that something that somebody can turn to and see codification of it, or is
So-
it just his experience?
No, it's not just his experience. Those standards and practices are oftentimes reduced to writing. They have been reduced to writing. So he protocols that are in place with him.
Okay.
Obviously, he's very familiar with FBI's protocols for investigative techniques and investigative protocols. He'll utilize those skills and that knowledge to assess his opinion, or to render an opinion, a conclusion concerning what he believes are the proper protocols that should have been followed in this case. That goes directly to our Bowdoin defense, and he is the primary expert that we would use to propound that Bowdoin defense.
All right. Can you get me that report before you leave? Do you have it extra?
I think
All right.
I think we probably have an extra copy of it. Yes.
Mr. Brennan, did you want to respond?
Of course he does.
Mr. Easter was a agent who did CAST. He did the CLSI. He made 100 cases to court and given his subjective opinion about how he feels an investigation was done. How many cases has he gone into court and testified, been allowed to testify about his personal opinion? His experience in the FBI is different than Canton Police Department and the state police. Argument by counsel so that they can use some type of opinion to lean on when they're arguing to the jury, they should have doubt because of the police investigation. I don't see any
Should.
recognition under 702 or in law where somebody can come in and subjectively give their opinions. If there is a state police protocol to follow, then the appropriate state officer ask if he did it and why. It gives a
StreamYard, I was not yelling at you, but I am about to.
why they chose certain actions that Mr. Easter is criticizing. I don't think this is an appropriate ground for defense and give their subjective opinion about an investigation they weren't involved with. I don't know that this witness has ever been qualified as a Bowden-type witness in any court. He may have testified, but about what? And so I think this is a very dangerous proposition. What if the Commonwealth wants to counter and bring in a state police officer to say that the investigation, that everybody did a remarkable job under the circumstances? What if
Did you miss the part where the lead investigator got fired, Brennan? Did you miss that? I don't think you did. I think they were talking about that earlier in the court and you were standing right there. I think you heard it. He got fired. Remember? He got fired.
that? This invites a debate between people's personal opinions. That's done outside of the courtroom, not in a courtroom. We will never have an opportunity to have all those come back to explain what this witness subjectively thinks was a deficiency. I don't think it's appropriate for expert witness testimony. This is government by counsel.
What am I supposed to do? Call a bunch of other PD officers to talk about how great their investigative techniques were? Yeah, there's another word for that. It's called rebuttal.
Whoa!
Love that. I'd love a shot
Okay,
at that.
so I said, let's not keep, take personal.
That's not an invective. That's not a personal shot at Mr. Brennan. I'm just saying, do it. You want to call in another expert? That's a classic battle of the experts. That's fine. I'll put Mike Easter up against any. Jurisdiction.
Yeah, Massachusetts case. If not, you can give me the outside cases, but I don't
I
believe
will.
there's a Massachusetts case where this has been done.
We have searched and of an investigation.
Right.
That is an expert field, one that's utilized throughout the
So
country
I
all
need
the
some
time.
authority, and the more persuasive the authority, the better chance you have at this. Okay?
Sure.
All right. So I think that's it for the motions in limine. Did I miss it? All right. Well, I need that, oh,
Your Honor, earlier you alluded to, this is what defense wanted to talk further about the ARCA issue, the Rule 14. You said we'll put that off until the end, if I heard you correctly.
I thought you, is that your understanding, Mr. Brennan?
Yes, and we have not.
Yes. So that was my understanding. So impanelment, you don't have anything for me for impanelment?
I regret we don't. We have not spoken.
Sure.
I know it's the court's preference to have each front and back questionnaire. I wonder if the assessment retrial publicity in this case, if would an age juror questionnaire last month in the case, there was kind of appropriate if in additional to the front and back, there was just one questionnaire that focused just on pretrial. I think it would expedite the impanelment.
I think that makes sense. Is the objection for defense on an extraordinarily, it makes sense to me.
Oh, I'm sorry, Your Honor, I was looking for outside cases.
All right. So I need questionnaire, and it can be that third page, Ms. McLaughlin. That's a great idea. And I was earlier when I was expecting something from the parties.
Sure you
All
are.
right. File your questionnaire, file your proposed questions that you would like me to ask the venire and that you would like to ask at sidebar. I need that by tomorrow. So tomorrow by the close of business, I need that. So if I need to see you again next week, we'll let you know on Monday. All right?
Yes, Your Honor.
Okay.
Obviously, it'd be a day after Monday then, Judge, right?
Yes, Mr. Unit, it would be after Monday.
We did file 2 motions today that at some point we'll need a hearing on. The
Okay.
defense just received notice this morning, so they're not prepared for today, but we would want a hearing on both of those motions. The sooner, the better for us.
So why don't we come in next week?
Well, nice. Now I'm gonna miss what day next week? Come on, Law and Crime. Well, dang it. Come on, Law and Crime, get your act together. Well, let me go see if I can find it on Court TV. Well, I don't see it anywhere. Maybe it's done. But now I don't know when the hearing next week is.
Now, which is why we have one of the reasons why we have our gusty yet.
I need some authority, and the more persuasive the authority, the better chance you have at this. Okay?
Sure.
All right. So I think that's it for the motions in limine. Did I miss anything? All right. Well, I need that. Oh,
Your Honor, earlier you alluded to, this is what defense wanted to talk further about the ARPA issue, the Rule 14. You said we'll wait for, we'll put that off until the end, if I heard you correctly.
I thought you and Mr. Brennan were going to talk about it first. Is that your understanding, Mr. Brennan?
Yes, and we have not.
Yes. So that was my understanding. So impanelment, you don't have anything for me for impanelment?
We don't, we have not spoken.
Your Honor, if I may, on one point on the impanelment.
Sure.
I just know it's the court's preference to have a one-page front and back questionnaire.
Yes.
I was wondering.
The day after Monday then, Judge, right?
Yes, Mr. Kennedy, it would be after Monday.
We did file 2 motions today that at some point we'll need a hearing
Oh,
on. The
okay.
defense just received notice this morning, so they're not prepared for today, but we would want a hearing on both of those motions. The sooner, the better for us.
So why don't we come in next week? Okay.
Okay. I have a headache. I have a headache. Bill from American Courts texted me this morning, wants me to call him when I get a chance. I don't know what I did. I hope I'm not in trouble. I'm gonna go lay down. Judy, when you find out when the next hearing is, let me know. I'm sorry, guys. It looks like the whole East Coast is having technical difficulties today, apparently. It's crappy weather here. I guess it's crappy weather there. And I got so excited that Lay's was now releasing all dressed chips in America. And then Walmart was sold out. So when I went out to do my errands, I went to Dollar General and they had them and they were 2 bags for $6. And I was extremely disappointed because they're not that great. They kind of taste like barbecue and vinegar together. I thought it was going to be like this major, amazing taste explosion in my mouth. And it was just kind of blah. I mean, they're not bad, but. And it says on the back of the bag, Canadians' favorite flavor or something like that. I was like, okay, well, now I've had them. I don't know why people order them from Amazon. They're like $30 a bag. They might not be that much, but they're a lot from Amazon because they're like imported from Canada. So they're a lot. Hey, Haley. I'm fixing to get out of here because I have a headache and I need to go lay down. And the technical difficulties are just getting the best of me today. I can't deal anymore. Can't deal. I've got to learn a new software thingy. I like StreamYard though. And it was going so good there for a while. And then they started adding stuff and it's crappy now. I mean, and I like the extra features, but it just isn't compatible with my equipment. Maybe if I start making money on YouTube and I start a business account and save up the money, thank you, sweetie, then I can buy a Mac. Like a high dollar, high level Mac. And then maybe that'll take care of some of the technical difficulties. Because maybe it's not my internet speed that's causing the problem. Because I just got new internet. I'm like 1 gig up and 1 gig down, which should be plenty to stream. I mean, I could go up to 2 and try that. It's not that much more expensive to go up to 2 gigs, so I might do that. I tried to do it on the app, but it didn't go through. I guess you have to actually call. I don't know why you can do it on the app if you have to call and tell them. That doesn't make sense. Like, if you can click it on the app, but it doesn't do anything, then why can you click in on the app? It's stupid. People do so many illogical things in the world. Make it make sense, people. So, between my technical difficulties, my disappointment in all dress tips, and oh yeah, I know, I've heard. It's embarrassing though. I keep apologizing, and people are like, "It's not your fault," and I know it's not my fault, but like I've got all these new subscribers and new members, and I'm embarrassed. It's like, who's gonna want to stay watching my things if StreamYard crashes all the time? I've lost count today. And then other days I'll go and it might crash once and everything else is perfect the whole entire day. There are some days I can leave my camera on. There are other days that I can't turn it on at all or nothing works. So it depends on the day. So it's weird. There's no consistency to it. One day, I'm trying to remember what I was streaming. What was I streaming? Oh, I was doing the Phil Spector trial, and the guy that was testifying, I think he was a some kind of forensic specialist. And his wife was actually one of the defense lawyers. So I put up a poll, my very first poll. In fact, it's the only poll I've ever done. I usually don't have enough people, and I think I had 12 people. So I figured that was enough to do a simple little quick poll. And I just put up, do you think it's a conflict of interest that he's married to a defense attorney? And it ended up being 50-50 because I had an even number of people. I don't know. I thought it was very, very much a conflict of interest for him to be part of the case that she's the attorney on. But he was actually part of the case before she was the attorney. But anyway, almost as soon as I put the poll up, and the poll, you don't do the poll through StreamYard, you do the poll through YouTube. But almost as soon as I put the poll up, StreamYard crashed. And so I got back, I got everything back. And somebody said, Debbie, quit trying to be fancy. I just want to be like other streamers and do what other streamers do. Streamer does not cooperate with me. I can't have nice things. Okay, y'all, I'm gonna go lay down and call Bill and see what I did now. I don't know what he wants, but it was enough to text me to call him, but not enough to text me, so I don't know what he wants. So he's been helping me with stuff, so it's probably just more YouTube advice. So it's probably nothing bad. Okay, guys, I love y'all, and I will see you. What's today? Is today Thursday? I don't even know what day of the week it is. Is it Thursday or Friday? Anyway, I was going to go to Orlando on Saturday and make that members only video, but now I don't know if we're going because my cousin, her son he caught a virus and she thinks she's coming down with it too, so we're probably not going to go. So there probably won't be a members only video. So if I'm not going Saturday, then we'll do full Spectre on Saturday. But I think today's Thursday. So we'll do full Spectre tomorrow anyway. If tomorrow's Friday. I don't know what day of the week it is, y'all. Bye. I love y'all.